questions on our WhatsApp text line. We'll make a time and read all those out. For those of you watching us on Facebook, can share the Facebook Live for other people to also watch tonight's edition of the program. My name is Justice Apia, and tonight on Hot News, we are unpacking the Supreme Court ruling on the rights of deputy speakers, to vote. And according to the Supreme Court, there's no article in the Constitution that bars the deputy speakers from voting in Parliament. This has generated a lot of issues with the minority having, their view on the matter. The minority in Parliament described the ruling as a travesty of parliamentary justice. But the majority in Parliament has also welcomed, the ruling from the Supreme Court. The former President, John Dramani Mahama, has also described the ruling or the judgment as regrettable and has advised the applicant to go for a review. President Akufo-Addo has also been, of which the Speaker of Parliament has responded to him. The Speaker of on the ruling, and exactly what we are discussing on. Joined in the studio by the Member of Parliament for Tamale North constituency, Honorable Al-Hassan Soini. Honorable, good evening. Thank you so much for joining us.
Good evening, Justice. Thank you very much for having me.
Very well. Finally, you are here.
Right.
Also in the studio is a private legal practitioner, lawyer Abdul Fattah Al-Hassan, popularly known as Jofa. Good evening, sir.
Good evening.
Thank you so much for joining us.
Thank you for having me, and good evening to your cherished viewers.
Right. I'll start with you, Honorable Sohini, on why you have described the judgment by the Supreme Court as a travesty of parliamentary justice. The Supreme Court has been very clear on the matter. They are saying that, yes, Article 102 of the 1992 Constitution is clear on forming a quorum. 104, of course, is also clear, on, members of Parliament voting and all of that. And that the Constitution under 104 has not barred any, Speaker of Parliament, Deputy Speaker of Parliament from voting on the floor of Parliament, considering the fact that they are members of Parliament who have been voted for, they've been elected to represent a constituency or constituencies, and by so doing you are disenfranchising their constituents. I mean, what's your view on this, and why have you described the said judgment as a travesty of justice?
Well, Justice, first of all, I think that we need to put a few things into perspective as far as the analysis of this judgment is concerned. One, we on the minority side have never argued that a deputy speaker cannot vote or is not entitled to vote, because even on the day that the minority prevented the first deputy speaker from voting because he was presiding, there was another deputy speaker representing the people of Fomina who was not prevented from voting. At every point in time, deputy speakers, when they are not presiding, have never been prevented from voting. Not in this 8th Parliament, and I don't know of previous parliaments. But in the 7th Parliament, deputy speakers used to vote. So no one has ever been in doubt about the need of a deputy speaker to represent his constituents. So you hear the analysis as if to say that we in the minority are saying that once you assume the title or the position deputy speaker, we are arguing that it denies you the opportunity to represent your constituents. That has never been our argument. Our argument has been that when you are presiding, then you are expected to be impartial, and you are expected to be a fair umpire. And so you are not to exercise your vote when you are presiding. And I'll, explain that further. The second issue that we need to also put into perspective is the fact that even as the ruling of the Supreme Court stands, even as we disagree with that ruling and hope that a review will set it aside,
right,
in my view, it is still a vindication of what the minority in Parliament did in preventing the Deputy Speaker of Parliament from voting on the day that he attempted to vote. Why? If you look at Article 110 of our Constitution, it states clearly that Parliament will be guided, will have the opportunity to set up its own procedures. So maybe for the benefit of doubt, let me just
that's actually what it is.
Yeah, I was paraphrasing, but let me just quote what it says.
Right.
Yes. So it says 1101, subject to the provisions of this Constitution, Parliament may by standing orders regulate its own procedure. Now, going by this, until this ruling, the standing orders of Parliament had in it under 109 that a deputy speaker will not have the right to vote.
But is that what the Constitution says?
Wait a minute. There is something they say about law not having retrospective effect.
Okay.
They are the lawyers.
Right.
Law does not have retrospective effect. So until the Supreme Court ruling, and I'm saying as it stands now, until it is set aside, I consider their ruling a vindication of what the minority did on the day we prevented the Deputy Speaker from voting. Why? Because until the ruling that just came, the standing orders was in line with 110 of our 1992 Constitution. It is now that the Supreme Court is setting aside that provision in our standing orders. Until they set it aside, it was part of the standing orders of Parliament.
Okay.
And so, if you look at 109 of our standing orders, it is clear that we did, no, it's not 109, 190, is that it? 1093, thank you. So 1093 of the standing order, Deputy Speaker or any other member presiding shall not retain his original vote while presiding. That's 1093.
This derives its validity from the Constitution under Article 104, isn't it?
I'll get there.
104 didn't say
I'll get there.
that a deputy speaker, it's just a speaker.
I'll get there. I'm just telling you the two things that we have to put into perspective. The first one being that, as a minority, our argument has never been that a deputy speaker can't vote. Our argument has only been that when he is presiding, he can't vote. And that is clearly captured under 1093 of the standing orders, which until the Supreme Court ruling was in line with 110, where we were told under 110 that Parliament may, by standing orders, regulates its own procedure. So until the ruling came, the whole of this standing orders was used to regulate our procedure in Parliament. So if this ruling says, if this current ruling says that they are expunging 1093, I am saying, and I'm submitting, like the lawyers will say, that what we did at the time we did it was lawful. Preventing the speaker from, the deputy speaker from voting was lawful, because at the time 1093 was part of our standing orders and it was lawful.
Right.
And it needed to be respected. Are you getting the point I'm making? So I'm saying until the Supreme Court ruling is set aside, which we believe will be set aside if, you know, the review process is given a fair hearing. Even as it stands now, that ruling vindicates the minority's decision to disallow the Deputy Speaker from voting on the day that he tried to vote.
Okay.
Now let's look at why we strongly believe that this judgment is flawed.
Okay.
If you look at Article 295 of our Constitution, 295, it's what do they say? It defines some of the terms and interpretation sections of the Constitution. So it interprets the Constitution for you.
Okay.
So under 295, you have 2951 in this Constitution, unless the context otherwise requires, Act of Parliament, then all of that, you know, they speak of all the things that you need to take into consideration when you are reading the Constitution. But then it also says something quite interesting. Just permit me to get to that portion.
Right.
And oh, I should have marked it on my way here. In fact, okay, it's actually 2952. 2952. In this Constitution and in any other law, a reference to the holder of an office by the term designating his office shall, unless the context otherwise requires, be construed as including a reference to a person for the time being lawfully acting in or performing the functions of that office. So the office of Speaker is there. The Speaker is there. But this provision says that unless the context otherwise requires, it will be construed as including a reference to a person for the time being lawfully acting in or performing the functions of that office. So anytime you have somebody lawfully acting as Speaker and performing the functions of the office of Speaker, the same responsibility that you place on the Speaker is placed on that person. The same responsibility you place on the Speaker is placed on that person.
Okay.
And you see, it's not for nothing that even in our Constitution, it is required of a Speaker to resign even when he is an MP and he's elected Speaker. It is to suggest the need for the person presiding to be impartial at the time that he or she is presiding. Otherwise, why will we require a Speaker to resign when he is elected as a Speaker, to resign as a member of Parliament when he is elected as a Speaker? We require that because it is expected that the person occupying that position should be impartial, should not take part or should not have sides when there is a debate on the floor, because Parliament is a house of debate. So when you have someone acting in his position, the same responsibility is expected of that person. And see, the ruling is quite interesting. The ruling actually confers all the rights and responsibilities of the Speaker on the Deputy Speaker. They don't question the fact that the Deputy Speaker, you know, is to play all the roles of the Speaker. But then when it comes to the issue of voting, at the time that he is presiding, they want, or the issue of taking sides, let me not just say voting, the issue of taking side, then they say he can take sides. Apart from all the responsibilities and rights of a Speaker accruing to the person, they do not expect the person to carry the liabilities. It doesn't happen anywhere. Where?
Are you not looking at the issue from just one side? Because the Supreme Court in its reasoning has also indicated that the Deputy Speaker or the Deputy Speakers are members of Parliament. They have been elected by their constituents. They are representing those constituents in Parliament. If you deny any of them their vote at the time they are presiding in Parliament, are you not disenfranchising their constituents and all of that, of the said vote in Parliament.
That is why I started by saying there was a need to put one thing in perspective. That the Speaker of Parliament, I mean the Deputy Speaker of Parliament, is never denied his right to vote at all times, unless when he's presiding. You cannot expect all the rights to accrue to you when you are presiding and shy away from the responsibilities. So when you are not presiding, you still occupy the position as Deputy Speaker. That is why their sitting is different from all other members of Parliament. They sit in front of the Speaker. The two Deputy Speakers sit right in front of the Speaker. Their offices are different. Their staff is different. So when you are not presiding, you still occupy the position as Deputy Speaker. But when a vote is called on a matter in the House, you vote. When you are not presiding, you vote. They vote all the time. But we are saying that when you look at all our laws, there's a reason why when you are presiding, you are excluded from voting. Look at Article 102 of the Constitution.
Okay.
Where even the footnote in the Constitution says quorum in Parliament. Quorum. Determining quorum in Parliament. And you see, I have done a simple definition. Sorry, the marginal note. Thank you, the marginal note. I have done a simple interpretation or definition of quorum. And there is no definition I have seen in my search of quorum that does not include voting. We vote to form a quorum or counting. So quorum in itself is a vote. You vote to determine whether there is a quorum. You count yourselves to determine whether there is a quorum. The process of determining a quorum involves voting. I don't know if you are getting the point I'm making.
I get it.
So 102 says, a quorum of Parliament, apart from the person presiding, shall be 1/3 of the members of Parliament. And they say the Constitution is a living organism with different organs. So you have to look at it in a whole. So before you even understand 102 well, look at 101. It says, the Speaker shall preside in Parliament at all sittings, and in his absence, a Deputy Speaker shall preside. 3 things to look out for: the Speaker, preside, Deputy Speaker. 3 things: the Speaker, the Deputy Speaker, preside. Those are the 3 words you should take into consideration. Then when you come to 102, it drops the Speaker, it drops the Deputy Speaker, but it says a quorum of Parliament apart from the person presiding shall be 1/3 of all members of Parliament.
Right.
So in this case, it is telling you that the 3 can be used interchangeably: the Speaker, the Deputy Speaker, the presiding person. That's what it is telling you, that it can be used interchangeably.
Isn't it the case that it is also differentiating the Deputy Speaker from the Speaker?
Listen to the 101. The Speaker shall preside in Parliament at all sittings, and in his absence, a Deputy Speaker shall preside.
So the Deputy Speaker is not the Speaker.
But he will preside. But he will preside. You understand? He will preside.
Right.
Then when it comes to 102, it says a quorum of Parliament apart from the person presiding. So in that case, it is telling you that it doesn't matter whether it's a Speaker or it's a Deputy Speaker.
Right.
The person presiding will not be included in a quorum. And remember, I told you,
it may not be the Speaker himself.
It may
be. It could be a Deputy Speaker.
It could be a Deputy. But that's what I'm saying, that it can be used interchangeably.
Right.
So it's telling you here that either the Speaker or the Deputy Speaker, whoever is presiding, shall not be counted when you are determining quorum. And I'm saying that quorum itself, the process of determining quorum itself, involves voting. It involves counting. So clearly, I fail to understand how the framers of the Constitution will exclude the person presiding from forming a quorum. But when it comes to making a decision, you think the person presiding can take part in making a decision. And that's under 104.1.
104.
It says, except as otherwise provided in this constitution, matters in parliament shall be determined by the votes of the majority of members present and voting, with at least half of the members of parliament present.
Right.
The speaker shall have neither an original nor casting vote. Where the votes on any motion are equal, it shall be considered law. Where parliament is considered a bill, and blah, blah. Now, here we are told that the deputy speaker is not mentioned.
Yes.
And because the deputy speaker is not mentioned, he can take part
In the voting.
process. But you see, if the constitution was going to list everything that it expects us to do, I think that it would have been more voluminous than this. It has already provided for you that to even determine if you can sit to do business, the person presiding is not part. I mean, that's the basic principle. That to even determine to do, like to decide whether you can do business, don't count the person presiding. How then do you think that the framers of the constitution had in mind that when it comes to taking important decision, the person presiding should now be part? Because you see,
the constitution mentioned the speaker.
What I'm saying is that no, I'm talking about
Says the speaker shall not have neither, casting vote or whatever. I think under Article 1042.
Yes.
It says the speaker shall have neither an original nor casting vote.
But you see,
Here, don't you think that
follow the trend, Justice. Follow the trend. Follow the trend. Yes. Follow the trend of the argument.
I get your argument.
Now, I told you in 101, the three, they have been given a certain responsibility and a certain role in 101. The presiding person, the speaker, and the deputy speaker.
Yes.
In 102, they are given a certain exemption again. And I'm saying that in 102, the exemption is even when you are doing the basic, determining whether you can have a meeting. They are exempted from being counted. Then 104 is when you are taking decisions. And when they list the speaker, I'm saying they don't have to repeat again the presiding person and the speaker and the deputy speaker. They have already done that in 101 and 102. They have already done that in 101 and 102. And again, and again, Justice, in 295, they have also told you that anybody who assumes that position, whether in acting or as a deputy, lawfully, is entitled to, carry out his duties the same way that the person who originally was in that position was supposed to carry out. In these standing orders again, we are told clearly that the person presiding shall be Mr. Speaker. In our standing orders, at the interpretation column, it says the person presiding shall be Mr. Speaker, shall be called Mr. Speaker. That is why when you are presiding, we don't call you Mr. Deputy Speaker. We don't call you Honorable Fomina or Bekwai. We call you Mr. Speaker. So when you look at our standing orders, that says the person presiding shall be Mr. Speaker. Then you look at, Article 295(2). That says that when you are when you are occupying a position lawfully at a time given, whether in acting position or as deputy, you carry out all the roles or you assume all the powers of that position. And you add that also to 101 and 102, where the person presiding, the deputy speaker, and the speaker are used interchangeably and given exemptions. Clearly, it tells you that when you are presiding, you are more than just a member representing a constituency. When you are not presiding and you are holding that title, you are representing a constitution and a constituency, and nobody can prevent you from voting and debating. They debate all the time when they are not presiding. But when they are presiding, they do not debate. And let me tell you, I mean, apart from even first deputy speaker's own words or admission that goes against this ruling. I'm sure you have seen that video.
Very well.
Where he himself says that he's not voting. That it is not in doubt that when you are presiding, you don't vote. He said it categorically in the chair. Apart from that, the illogic the illogic in the argument that the person presiding can vote, especially during division, is expressed in the procedure to determine a count when you call for a division. If you look at our standing orders again, how do we get to a point where you call for division? So the speaker puts a question. Those in favor will say, yeah. Ayes. Then those against will say no. The speaker will use his ears and decide to call the votes for the side he thinks was loudest. So he can say the nays have it. At that point, as a member, if you feel aggrieved or if you think the speaker's ears failed him, you can rise to demand that a division be taken. Now, when you are calling for a division, you are calling for the voices to be counted. The voices that took part in the vote to be counted. Not the voices that didn't take part in the vote. Because the vote is already done. But you now want to distill it to the voices that took part in the vote.
Right.
Are you getting the difference? So the first deputy speaker admits to us that it is not in doubt that when you are in the chair and you call for a vote, you don't take part. So when you call for a voice vote, you don't take part in that voice vote. When they are counting the voices to determine which voice is louder, your voice cannot be part of it. I don't know if you get the simple logic.
I get it.
In the argument that the person presiding, when he was not part of the voice vote, can now step down so that they will count him. I mean, you are here. Then I say, I'm calling a voice vote between the two of you. Or let's say the producers here.
Right.
I say I'm calling a vote, including the producers. Then you say aye. The ayes will say aye. Then you say no. Then I say okay. The ayes have it. And you, Justice, you say that no, the ayes don't have it. So let's count the people who voted. And you have already determined that me, I don't take part in the shouting.
Yeah.
I won't take part. Then we are counting the voices. Then I now come and say I was part of the ayes. I mean, logically, it is simply irrational for anybody to think that that is what the framers of the Constitution intended when they prescribed that the speaker, the deputy speaker, the person presiding cannot be counted to form quorum. But when it comes to the serious business of taking a decision, the person presiding, if it is not a speaker, can take part. I think it is simply unacceptable, and we agree with all those who are calling on the plaintiff to seek a review of the Supreme Court's decision. We think it's a travesty of justice, and it must not be allowed to stand. It is not a ruling that must be allowed to stand. It is dangerous for our democracy.
Right, I'll come back to you. Viewers, you are still watching Hot News right here on African Television with me, Justice Apia. Those of you watching us on Facebook, and share the Facebook Live for other people to also watch tonight's edition of the program. Now, let me come to you, lawyer, on the arguments. I've listened to the majority side on the matter. I've listened to the minority. You've listened to Honorable. He has espoused succinctly the minority's views on the matter. As a lawyer, has the Supreme Court erred in their decision? I'm sure you've read the judgment.
Yes, thanks, Justice. I have read the judgment. I think it's a 29-page judgment. And I have actually seen the difficulties the 7 justices of the Supreme Court went through in arriving at this decision.
Right.
When you look at it, the arguments they are putting forward, if you are going to logically follow their own arguments, you won't arrive at the conclusion they arrived at.
Why so?
For instance, if you say a deputy speaker by the provisions of our own constitution, before assuming that position as a deputy speaker, was a member of parliament. You understand? And so, even as a deputy speaker, he's still a member of parliament. And so he represents his people. And so he should not be denied that
His
voting
right to vote. Yeah.
The question is, do the electorates in the constituency, the voters, do they vote the MPs only to come and vote? Don't they also elect them to come and deliberate?
Okay.
Because before you arrive at voting, you should have gone through deliberations. So, what does the Supreme Court say about the right of the deputy speaker to take part in the deliberations? Can he, at the time he's presiding, also choose to raise his hand, and who will call him, to catch whose eye, and make what kind of input, and to whom, and who will he be addressing? Myself, or because when you are talking, you people, you address Mr. Speaker, so who is he going to be addressed? And so they have kind of belittled the power given by the voters in our constituencies to their MPs. They have reduced it to just voting. And so that deputy speaker has no clue. He has no useful purpose to serve our nation except to vote. That is
no, but that was the review. That was, I mean, the interpretation the person went to court to, of course.
That was the decision. The court came to the voting.
But the person went to court, you know, to seek an interpretation on Article 102 and 104. And precisely it was on that. So and what they didn't want to. Of course, you can also imply
when you look at what the provision areas. When you look at the provision Honorable mentioned 110. In fact, if the Supreme Court had considered 110 appropriate, there would have been no need for any form of interpretation.
110.
Yes.
Okay.
Because it's clear. It says subject, that is 1101, subject to the provisions of this constitution.
Okay.
Parliament may, by what? Standing orders, regulate its own procedure. So it means that Parliament has the right
so the constitution has given them that mandate.
And they are only subjecting it to one condition.
Okay.
They say that the only time they cannot make orders to regulate their own procedure is when there is a constitutional provision. Now,
but what if they have a provision in the standing orders that is, you know, inconsistent with the provision with the provision in the constitution?
So, if I ask you, what provision in the constitution is the standing order 109 rule 3 violating? In fact, when they started this whole interpretation thing, the Supreme Court itself came to the conclusion, the plaintiffs, the respondent, the states, and every party in the action came to the same conclusion that there is no clear provision in the constitution saying that a deputy speaker should vote. That is not in doubt. Just as they are saying there is no clear provision that says he shouldn't vote, there is also no clear provision in the constitution that says what? A deputy speaker should vote. There is no such provision in the constitution. Now the question is, saying that subject to the provision of this constitution, Parliament may by standing order regulate its own policy. So when there is no provision in the constitution, you can't take away the power of Parliament to make its own orders. That is what this means.
But there's a provision under Article 104 on the voting right of the speaker. It talks about the Speaker of Parliament. It never talked about deputy speakers of Parliament.
So, and there is a conclusion that there is no explicit provision that gives the deputy speaker the right to vote.
Yes.
That is settled. So if there is no provision, allow Parliament, the court said if there is no such provision, allow Parliament to make orders. Which was why Parliament made the orders that today 1093 stands for expunged. So the Parliament was perfectly in order. Now if you read the judgment, one surprising thing that came to was how the Supreme Court took time to extol the long-standing principles and conventions in other parliaments. You look at the UK, you look at the US, in fact, Botswana, Kenya, Supreme Court took pains to look at, apart from the positions in their laws, their conventions, parliamentary practices, long-standing established practices. The question is,
what prevented Supreme Court from going into our own practices?
Right, viewers, you are still watching Hot News Radio on Pan African Television with me, Justice Apia. Keep your messages coming in. We'll make a time and read all those up for you. You can as well join us on Facebook. Share the Facebook Live. We'll make a time and read all those up for you. Now, let me come to lawyer once again. You can go ahead.
So, there's a paragraph, a subheading in their ruling called comparative analysis.
Yes.
Where they went to town. They went to the U.S. Congress. They went to House of Commons in the UK. And they are respecting and extolling their established practices and conventions in Parliament.
Okay.
But when you come to our situation, Ghana, Supreme Court did not give a listening. They didn't give any attention to what has been the practice in our own Parliament. And it is a settled principle that our practices and conventions are also aids to interpretation. So if Supreme Court was minded to interpret the Constitution based on whether the deputy speaker has right to vote or not, they were supposed to go back to our parliamentary practices for the past 3 decades, since the inception of the 1992 Constitution, to find out what has been the practice in Parliament. If there is a certain practice in Parliament, that should also aid the Supreme Court in his conclusion. But the Supreme Court paid no attention at all to what has been happening in our Parliament. Rather, they were talking about things happening in UK Parliament, things happening in US Parliament. And I find that quite unfortunate. Another point, worthy of consideration. And Honorable mentioned that Article 295. If you say, because the Constitution did not explicitly say Deputy Speaker does not have a voting right, but just says the Speaker, to you, the Deputy Speaker should have a voter because he represents the constituency. Article 295 is very clear. It says what? When the Constitution is making reference to a particular position or office, that same reference in equal magnitude, lawyers will say mutadis mutanda, in equal magnitude, that same reference is made to a person acting in that position for any time being. And so if even the Speaker is not there, and the Deputy Speaker assumes that role as a Deputy Speaker, Article 295 of the Constitution is clear that Deputy Speaker, as far as he's assuming that role, a reference to the Speaker is a reference to him. So whether he's called a Speaker, what is a non-starter. So this issue of non-voting quorum in Article 102 and voting quorum in Article 104, to me, was not necessary. It was completely unnecessary. The person, look, one of the ethos of our constitutional, of our laws, in fact, I won't even go to constitutional law, every part of our law, is that the issue of impartiality and the need to avoid partisanship, especially when we are presiding over proceedings, even in administrative law, it's not debatable. And so when you sit in that chair, you are assuming a particular rule, so that you have the option to choose who will talk at what point in time, and when you stop the person. It is not for nothing. In fact, if you look at I read their comparative analysis, and if you look at the countries that they made references to, for instance, they will say that when a person, I think in the US, when the Speaker is elected, and the Speaker in the US is elected from the elected MPs, you understand? In that case, what happens is that in the UK, he chooses to belong to the party. He chooses. In fact, it's not even a choice. It's mandatory. He does no longer belong to the party that elected him. Yeah. And he cannot involve himself in campaign, in other things. And to me, these are things that we should learn from. The spirit of our Constitution is clear that you cannot be a judge in your own court. And that is the two principles we have in natural justice, the rule of natural justice. And so to now ascribe the Deputy Speaker the powers of a Speaker, in addition the powers at the time he's presiding, and I like the distinction Honorable made, that the minority side in Parliament is never against a Deputy Speaker voting. No. But when that deputy speaker mounts that high seat, he ceases to be seen as just an MP. He is now presiding over the affairs of parliament. And once you are presiding, at least you should owe the state a duty not to take sides. Otherwise, then the whole business in parliament will be shambolic. So, to me, the concept of separation of powers, in fact, this issue we have, and you see the Supreme Court, one danger I've seen about this is that, the Supreme Court has the power to change its positions. There's no binding precedent when it comes to Supreme Court decisions. And so today, this decision, even if you don't go or review, tomorrow the Supreme Court can make another pronouncement that contradicts this decision. That is why they are telling you that when it comes to internal affairs of parliament, and if you look at from Article 100 going, it's a procedure in parliament. So procedure, voting is a procedural issue. It is within parliament. And you have held in J.H. Mensah in Attorney General in 1997 that the Supreme Court has no power to dictate to parliament how it should conduct its own internal affairs. So what has changed?
But they are clothed with the power to interpret the constitution.
That is why, and look, even in this instance, what the Supreme Court has done, vis-a-vis any attempt to deny the deputy speaker his right to vote when he's presiding, to me, the offense or the harm caused by this decision is more heinous than the harm caused by minority members preventing the deputy speaker from speaking. Because clearly, this action is a violation of Article 110, which says if there's no provision, allow Parliament to make orders. There's no clear provision, which is clearly settled. Parliament makes its orders, and you say those orders are a violation of what provision? There's no provision. In fact, they are placing their interpretation on certain provisions. And this Article 1101 does not give you the power. It doesn't say subject to the interpretation of the provisions of the Constitution.
I get
A provision is clear. You understand?
Right.
So clearly, we are in very difficult times. And I don't subscribe to the call by people that the guy should go for review.
For review.
I am not.
Why don't you subscribe?
No, I'm
that?
not. I don't subscribe to that because I don't see us getting anywhere with that. We have 7 people. The review, they just add 2 to the number. It will become what? 9. You need at least 5.
You don't think that those 7 people are able to change their position on the ruling?
In fact, it's almost like riding a camel through the whole of a needle. It's almost impossible.
I see.
Yes.
Right. Let me go to Honorable.
I understand the apprehension of lawyer. I understand his apprehension because clearly, in my view, this is a political judgment, and that is why I agree with the minority. Partisan. I should even say partisan judgment.
The Supreme Court.
The Supreme Court is a political, bench. So I should even
bench.
It's a political bench.
How?
I mean, they are interpreting the Constitution. So most of their cases are political. But I want to be very, specific and say that it's a partisan judgment, a very partisan judgment. And that is why I appreciate his apprehension. That is why I appreciate lawyers' apprehension that nothing may change, even if we go for a review. And I agree with the minority leader when he says that this ruling is judicial support for the e-levy. It's judicial support for the e-levy, clearly and squarely. And I've identified a number of biases, maybe call it 3 biases or 4 biases. That shows in the ruling. For example, a lawyer made that point. The focus, the bias of the judges was on voting and not all the other things a member of parliament is expected to do in representing his constituents. The focus was on voting. Why? Because there's e-levy voting. The focus, the bias of the judges was on voting. And so they did not broaden their mind to include other roles that a member representing a constituency plays on the floor. Because the most essential role a member plays is representation, is deliberation, is debates. But to reduce it to only, to reduce it to only voting, it's clearly unacceptable. It just shows the bias with which they were looking at this case. So they think that once the deputy speaker presiding can vote, end of story. I think that is the first bias that did not serve the justices well. The focus on the e-levy voting. If they had broadened their minds beyond just voting, perhaps they would have realized that the Constitution, meant well when in clear provisions and in logical interpretations disallowed the deputy speaker from being part of proceedings in the House, including voting. The second bias I see, bias I see is the suggestion in the ruling that if the deputy speaker is disallowed from voting, it can lead to deliberate absence of a speaker. Opportunistic, that's the word they use. Opportunistic absence of a speaker. You know why? Because I think the justices who sat on this case have listened to wrong filler in the public domain, especially from the NPP side, where the communication suggested that Speaker Bagwin refused or deliberately refused to sit during the voting. So they have been influenced by that wrong information, that wrong notion, that clear propaganda that the NPP communicators spewed out about Speaker Bagwin, because the evidence is clear that every time the speaker has been absent, it has been as a result of the inability of the majority side to take advantage of his presence until he was absent. And then they hit the blame on him. The last time he was there from morning, kept asking them to bring the e-levy. They did not until when he thought that they were not interested in doing the e-levy late in the evening, went home, and then they brought the e-levy and claimed he had vanished. So that propaganda against Speaker Bagwin influenced the justices on the bench to suggest, without thinking further, that we may not even have the same numbers in Parliament again in the future. But that bias reflected in their suggestion that the deputy speaker not voting will lead to opportunistic absence of the speaker. That is a clear bias there. Bias influenced by propaganda from the New Patriotic Party against Speaker Bagwin. Then you have, again, and lawyer was very succinct on it. The provisions of the Constitution. 1093 of our standing orders is not against any provision in the Constitution. They have failed to show us the clear provision that it is against. It is against their interpretation. And that is not what Article 110 says. That's not what 110 does not say that subject to interpretations. No, it says subject to provisions. But you see, yes, it has to be there for you to now say that 1093 is against this particular provision.
It's inconsistent with this
particular provision. There is no such provision in the Constitution. What is against is their interpretation. But 110 did not say it should be about your interpretation. That is another bias that I see there. Because there's no clear constitutional provision that 1093 is against. 1093 only sought to expand on 101, 102, and 104. It only expanded on it. Clearly, that bias also is what influenced the justices to go the way they went. Now, finally, the fourth bias. How do you separate quorum in 102 from quorum in 104? I do a simple analysis again. I like simple, basic analysis. So the qualification to enter class 1, or let me say, the qualification to enter SHS 1 is that you must have aggregate 12. If you don't have aggregate 12, you can't enter SHS 1. But you say that I agree, I can't enter SHS 1 when I have aggregate 12. But when they are going to sit for the WASI exams, even though I don't have aggregate 12, which disqualifies me from entering SHS 1, I can take part in WAEC. Are you getting the logic? So you say that in 102, the person presiding does not qualify to be counted as quorum. But then when you go further to 104 and they are going to take a decision, he's now qualified to be counted. I don't qualify to enter SHS 1, but I am qualified to sit for WAEC in SHS 1.
But let's see the reverse of what you're saying. That to them, 102 is clear on who forms part of a quorum.
Yeah.
But when you go to 104, there's no provision. It is not clear. I mean, nothing but the deputy speaker.
Again, with that same logic, I take you back to 1093 of our standing orders.
Right.
If you are saying that if it is not stated, then you can put any interpretation on it. We are also saying that they should show us the clear provision in this constitution that 1093 is against. There's no such provision. So you cannot reprobate and approbate.
Okay.
You cannot say that 104 it is not stated. So you cannot say that the person cannot vote because it's not stated. But you come to 1093, it is not stated in the constitution, but you say that 1093 should not stand. It's not also stated, so it can stand. Do you get the argument? So I'm simply saying that, look, these justices have been influenced by some partisan biases, and that is what resulted in this flawed ruling. It is my hope. It is my hope. I mean, Parliament, we will take our own decisions. We, the minority side, will consult widely and will take our decisions in line with the 1992 Constitution.
Okay.
But in the meantime, I am still hoping that this may have been a genuine error. And that since they are minded to listen to public opinions, that is reflected in the biases I stated, like the opportunistic absence of the speaker.
Yeah.
I am hoping that they will continue to listen to public, sentiments. And those public sentiments will influence their, review, the outcome of the review. But finally, let me share with you another provision of the Constitution that is quite interesting.
Right.
297H.
Okay.
297H. It says, whereas directing or empowering a public officer to do any act or thing or otherwise applying to him by the designation of his office. Justice, I want you to listen to it.
I'm listening. I'm reading it.
Include his successors in office and all his deputies and all other assistants. I want to take it again.
Right.
The where's directing. You remember we spoke of 101?
Yes.
And what the speaker cannot do.
Right.
And what he can do. And 102, what the speaker can do and what he cannot do.
Exactly.
So it says, where's directing or empowering a public officer to do any act or thing or otherwise applying to him by the designation of his office, include his successors in office and all his deputies and all other assistants. So clearly, 297H is telling you that where's responsibilities conferred on the main person occupying the office are conferred on his deputies and his successors when they assume that office. And remember, I already shared with you 295.
Right.
So, like I said, the Constitution, some lawyers say, is a living organism with different parts all briefing. So you cannot hold one part and make a correct interpretation. You need to look at all these parts and be informed by the spirit
So by your argument,
of the Constitution.
a deputy speaker, once he assumes the seat of the speaker.
Of the speaker.
Becomes a speaker.
Becomes, as I am not saying it, 2978 says that the words directing or empowering a public officer, in this case the speaker, to do any act or thing, or otherwise, to do or not to do, applying to him by the designation of his office, include his successors in office, and all his deputies and all other assistants. So when he delegates, I mean, all of that, when they assume, when the deputy speaker assumes the office, and it gets the designation Mr. Speaker, all the acts that he can perform and acts that he cannot perform, when he himself is sitting, extends to the deputy, the assistant, you know, and the successors who take that office.
That's very clear.
That is why I'm saying that, but for the partisanship that influences justices, the propaganda that influences justices, where their focus was only on voting, because e-levy is the headache of this government, and not other, you know, roles that a member of parliament is supposed to play. Because like lawyer said, voting is one of the least things a member of parliament does to show how well or not he's representing his constituents. Voting is a list. Deliberation is key.
It's very true.
Oversight is key. You know, and all the other things that we know members of parliament do are key. But the bias is on, you know, an e-levy before them. So if they had considered all of this, yes, the issue was about whether the speaker can vote or not. Yes, I agree. But I'm saying that if they had considered all the other duties of a member of parliament, their argument wouldn't have just been that when you disallow the speaker from voting the deputy speaker from voting when he's presiding, you are disallowing, or you are being unfair to his constituents.
Disenfranchising his constituents.
No, that they would have seen that at every point in time, the deputy speaker of parliament represents his constituents fully, except when he is presiding, where the law under 297H, 2952, and 102 all say that when he is presiding as speaker, he's expected to be impartial, and he's supposed to take on the cloak of the speaker and act as the speaker.
Now, my final question to you. We all know that the judiciary is independent. By some statement emanating from the quarters of the minority, as you know, the judiciary or the Supreme Court justices being partisan, as the judgment being, a judicial support for the approval of the e-levy, are we not soiling the reputation of our justices? Are we not soiling the reputation of the judiciary?
Nobody,
by those statements.
You see, nobody does better PR than, you know, the product itself. You cannot do PR beyond the qualities of a product. If a product is good, that's why the accounts will say what? That exactly. Nobody can do bad PR if your conduct does not lend itself to such, you know, PR. So the justices themselves must begin to look at their own rulings. I mean, Professor Atuguba gave them the opportunity, but like ostriches, they decided to bury their heads in the sun. When he came out with his research, you know, report, highlighting partisan judgments or political judgments, as he put it, based on research, and showing how rulings went depending on which regimes, you know, got them on the bench.
Right.
That for me should have been a wake-up call, something to call for some reflection. Because you see, again, our people say the one cutting the path does not know if his back is crooked or not. They may be genuinely convinced that they are doing their very best to be fair and impartial. But the Constitution says that they exercise their powers in the name of the state, in the name of the people, sovereignty lies with the people. Supremacy is with the people. So they exercise their powers in the name of the people of Ghana. And so when the people of Ghana begin to raise concerns about their conduct, it is not because they want to swell their reputation. It is perhaps because they want to draw their attention to their weaknesses, because every human institution has weaknesses. And so the intention of the minority is not to swell the image of the judiciary. And, you know, I was taken aback recently when my colleague, Sosu, said about judicial political judges. And what did he say? Judges who are political will be given
political treatment.
And the Judicial Council and others had the effrontery to claim it and to demand an apology. I was taken aback. I mean, like we say in our village, I mean, you are in the market. To it, you are in the market. And then they scream, thief, 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 and you start running.
If you are not a thief,
are you the only one in the market? If you are not a thief, why are you running? They say if they are political judges, if they behave politically, they will be treated politically. And say, hey, why are you saying that? Are you a political judge? It's just like they say, in this town, we chase out all the witches. Then you start packing your bag and say they are coming to attack you. Has anyone called you a witch?
Means you've declared yourself a witch.
That is why I was embarrassed. I was shocked that they behave the way they behave.
Right.
So I am saying that they should take some of this as feedback, meant to help correct the system, because they are not angels. I mean, Anas showed us that they are not angels.
It's true.
So they must take this as feedback and not as an attempt to swell their reputation.
Right. Thank you so much, Honorable, for coming. I'm so grateful for your time. Well, can Lee take us home?
Thanks so much. I think, you see, from 57 to date, we've had like 5 constitutions. It is not for nothing that from 69 to date, if you look at the 69 constitution, the 79 constitution, and the 1992 constitution, we have moved from the 57 and 60 constitutions. The 57 and 60 constitutions, we had what we call the parliamentary supremacy. Side that parliament had power. In fact, it's just like what is happening in UK now.
Right.
To make it, in fact, no court, 57, 60, no court had power to question any law made by parliament. 57, 60. And you remember the famous Ria Akutu.
Yeah, the Ria Akutu case.
Now, we learned some bitter lessons from that structure. And so in 69, there was a shift from the parliamentary supremacy to the constitutional ways. Say that parliament itself, when it makes its own laws, the laws can be subjected to interpretation enforcement by another body. And so 69, 79, and 92. And so we should be very careful, because it means that there was a way that did not serve us well, and then we shifted. What we have all embraced now, it is a duty on us all to ensure that we guard it jealously, because we all want to see the constitution be applied to the letter. If you read this judgment, you wonder what kind of interpretation was placed on it, because you know you are in the law school, you have the canons of interpretation.
Very well.
At some point they are using purposive approach to interpretation. At another point they are using literal. The literal one was where you were coming with your question, whether they said speaker and they didn't say deputy speaker, and they themselves have said it. They said the constitution did not literally say speaker, deputy speaker. So that is literal. But when it came to other areas, they said they looked at
the intention of the framers of the constitution, and they said that the intention of the framers was to deny the speaker and not the deputy speaker. The same area, you are using purposive and literal. So it looks like when they want to go this way, they shift to this position. Because when you should adopt one. Let's see the approach. You ran through the whole judgment. But the moment you do this,
and that is why I was surprised that there was no dissenting opinion.
Right.
Because
it's very surprising.
The dissenting opinions sometimes enrich the
yes, they do. They do.
You understand? They may not even win the day, but they will raise the other side of the argument in an intelligent way. That you know, that's I get surprised that we get these unanimous decisions. They don't help even the judiciary.
It's becoming alarming.
It's unacceptable.
Finally, lawyer, would you agree with people who think that, look, the judiciary and then the legislature are co-equals, and the judiciary cannot direct the legislature on what to do? By this ruling, they are trying to tell Parliament what
that is the fear. That is, in fact, we are now beginning to entertain the fears that the judiciary is now making serious incursions into areas reserved exclusively. And you see that they say that the issue of political question doctrine does not apply in Ghana. But we have provisions that clearly stop the judiciary from interfering in the internal affairs of Parliament. You understand? And their own decisions, Supreme Court's own decisions, like I said earlier, Judge Mensah and Attorney General, where Judge Mensah was insisting that the vetting should be done this way and that way and that way.
Right.
And Supreme Court said what? How Parliament will go about vetting its ministers? Because it's an internal matter. So we're expecting this judgment to equally uphold the same principles that have been upheld right from the word go, in terms of the need to preserve the sanctity of Parliament when it comes to managing its own internal affairs. No one is saying that the output of Parliament should not be questioned. When it clearly violates an explicit provision in the Constitution, then clearly it does not have legs to stand. And so we have no problem. But this one, in fact, the Supreme Court is struggling. It has struggled all through this judgment to establish which provision in the Constitution has been violated by Order 1093.
Are you convinced that this could also be a partisan ruling, judgment, pronounced by the Supreme Court?
You've just heard Order will make reference to.
No, I want to send
I am a lawyer.
Yeah. Very well.
You understand? And so the same is so applied.
They found the answer before they started working. They found the in mass. They say show working. So they got the answer and they were now struggling.
Right. Thank you so much for coming on, and I'm so grateful. I mean, I would want to have you more often on this platform. Actually.
Thanks so much.
Thank you so much for coming. I'm so grateful.
Yeah,
this
thank
is time
you
we'll allow the program. Make a time with us. Same time tomorrow. My name is Justice Ruby, and the show has been Hot News. Goodbye.
Truly African.